Hello, I'm Dominic Walker, JMW's Inside Man. I'm with Emma Benson. Emma is a Senior Associate Solicitor in JMW's Family Department. Hello, Emma.
Hi, Dominic.
Emma, so we wanted to talk about divorce, and I hear these terms, decree nisi and a decree absolute. What's the difference between the two?
So decree nisi is the first part in the two-stage divorce process, culminating in a decree absolute, and it gives the court the power to make a financial order. So assuming that a respondent has not indicated an intention to defend the proceedings, a petitioner can apply for decree nisi as soon as the time limit for the respondent to have returned their acknowledgement of service to court has expired. And this means that it's usually 7 business days after the date on which the respondent will have received the divorce petition. So when the court receives that application, they will check to confirm that the respondent has received the divorce petition, that they're not going to defend the proceedings, and that the petitioner is entitled to a decree nisi. And assuming that is the case, they will then list the application to be heard by a district judge on the first available date, and they'll make any directions necessary in respect of costs, assuming that a petitioner has made an application for the respondent to pay their costs of the divorce or to make a contribution towards those costs. And once decree nisi has been granted, a petitioner can then apply for their decree absolute, which is the final divorce order, 6 weeks after the date on which decree nisi has been granted. Alternatively, if the respondent's going to make that application, then they can do that 3 months after the earliest date on which the petitioner has been able to apply. And then once the decree absolute comes through, that's the final divorce order, which means that you're officially divorced.
And do all financial matters have to be resolved before that final order, before the decree absolute?
It's prudent to wait until you have a financial order in place before you apply for a decree absolute. And the reason why that is because a party may lose certain benefits in the event that their spouse were to die after decree absolute is granted, but before a financial order has been made. And a good example of that is in respect of pensions. And so if you're no longer married to the person who holds the pension and they die after decree absolute, but before a financial order is made, then you no longer have the special status of being a widow or widower. And it's unlikely that you would be able to retain the types of financial benefits that you would if you were still married to that person at the point that they were to die.
Divorce is clearly an emotive time. It's an emotional time. Do you think it's important to seek advice from a solicitor at an early stage?
There's no requirement for you to do so, but it is advisable to take legal advice as soon as you can. And JMW can guide you as to the best strategy to be adopted to ensure that you get the best possible outcome. And our clients often find that having us on board to support them from an early stage in their case helps to alleviate the stress that they may be feeling and to try to eliminate any feelings of uncertainty that they may have as to what the future holds for them.
Emma, thank you so much for your insight. And if you'd like to speak to Emma or a member of the Family Law Department, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.